On the 9th of January 2026, a federal judge in Manhattan is scheduled to hear a motion that could change the stakes in one of the most watched criminal cases in the country. The defense for Luigi Mangione wants the death penalty taken off the table. The motion claims the decision to seek capital punishment was tainted by a conflict of interest at the top of the Justice Department. That is the headline. But the real story is inside the filings. I'm Tim B., and this is True Crime Animator Studio. Today is a Court Docs episode. I am not here to guess. I am here to break down what is filed, what is publicly confirmed, and what is still unknown. Quick respect note before we start. Brian Thompson is dead. A family lost a husband and a father. And Luigi Mangione is accused, not convicted. An arrest is not a conviction. Here is what is confirmed about the case posture. Federal prosecutors in the Southern District of New York charged Luigi Mangione in December 2024 in connection with the killing of UnitedHealthcare CEO Brian Thompson. The Department of Justice also publicly described the federal charges in the 19th of December 2024 press release. Separately, the Manhattan District Attorney's Office announced a state indictment in December 2024 tied to the same death. So, this case has two lanes at the same time, a federal case in Manhattan and a state case in New York. And that is why the calendar matters. In the federal lane, the Justice Department announced on the 1st of April 2025 that Attorney General Pam Bondi directed prosecutors to seek the death penalty in the case. That announcement is not a rumor. It is an official Department of Justice statement. Now, when the government says it will seek the death penalty, that does not mean a death sentence is inevitable. It means the prosecution is pursuing a capital-eligible path if the defendant is convicted. The defense can fight that decision. The court can review parts of that process. And jurors, if the case ever gets that far, still have to decide guilt first. This is the first open loop. What is the defense asking the judge to do right now? Here is the cleanest plain English version. The defense filed a motion asking the federal court to strike or block the government's pursuit of the death penalty in this case. The defense also challenges two federal charges, according to recent reporting that describes the filing. The core argument is that the decision-making process was compromised because of a claimed conflict involving Attorney General Bondi. The defense points to Bondi's prior work connected to Ballard Partners, a lobbying firm that has represented UnitedHealth Group's parent company. In the defense view, that prior relationship creates a conflict that should have required Bondi to recuse from directing capital punishment in a case tied to a UnitedHealthcare executive. The defense also seeks discovery, meaning documents and information about Bondi's compensation, any ongoing financial ties, and communications or directives connected to the death penalty authorization process. That is the allegation in the motion. It is not a finding. This is the second open loop. How does a conflict of interest claim work in a real federal case? In general terms, a conflict claim in a prosecution is about impartiality in process. It is about whether a decision-maker had a personal or financial interest that could undermine fairness or create the appearance that the system was used for reasons other than neutral justice. The defense does not need to prove the entire case right away, but the defense does have to show the court a concrete legal reason to intervene, and the government is already pushing back. Prosecutors argue that public commentary and political noise do not automatically invalidate a prosecution. They argue that court safeguards, jury selection, and normal trial procedures exist to protect the defendant's rights. They also argue that the defense is trying to turn politics into a legal shortcut, so the judge will have to sort a narrow question. Not, what do you think about the death penalty? Not, what do you think about the headlines? The judge's question is closer to this. Did the process used to authorize capital punishment in this case violate a rule that requires a legal remedy? Now we get to the date that matters. Associated Press reporting says the federal court has a hearing scheduled for the 9th of January 2026 in Manhattan related to these issues. This is a procedural milestone you can actually put on a calendar, and here is why it connects to the state lane. In the New York State case, there has been extensive litigation about evidence. After weeks of testimony in December 2025, Judge Gregory Caro said he will rule on evidence admissibility on the 18th of May 2026 based on reporting of the state proceedings. The defense has argued that certain evidence and statements should be excluded. Prosecutors have argued that the searches and seizures were lawful. I am not going deeper than that in this episode, because the details can become graphic or weapon-focused, and that is not what TCAS does. The only point for today is that the state judge has not ruled yet, and the ruling date is set. So, look at the structure of the next few months. The 9th of January, 2026. Federal hearing on a motion tied to the death penalty decision and related federal charges. The 18th of May, 2026. State ruling on what evidence can be used at trial in New York. That is a high-stakes legal chessboard, and none of it is final. Now, let's talk about a key context point that can get lost in the noise. In September 2025, a New York judge dismissed certain terrorism-related counts in the state case. According to the court's written decision and reporting by Reuters and the Associated Press, other state charges remained. That matters because it shows the defense has already won at least one significant procedural fight in the state lane, and it reinforces the theme of this case. Motions matter. Now we get to the third open loop. What happens if the federal judge agrees with the defense? Here are the limited, realistic outcomes. 1. The judge could deny the motion. The death penalty remains on the table, and the case continues with that risk profile. 2. The judge could grant some part of the relief. That could mean the court blocks the death penalty path, or orders more information, or narrows the government's options. The details would depend on what the judge finds and what remedy the law allows. 3. The judge could set additional deadlines and hearings to build a record before ruling. In major cases, judges often demand a clean paper trail before deciding anything that can reshape the case. What cannot be said today is what the judge will do. Authorities and courts have not confirmed any outcome, because the hearing has not happened. Now, I want to slow this down and make the process clear. Because the words sound dramatic, but the mechanics are very specific. A motion is not evidence of truth. A motion is a request. It is one side saying, here is the rule, here are the facts we think matter, and here is what we want you to order. A press release is not a verdict. A press release is a public announcement of the government's position. A hearing date is not a turning point by itself. It is the moment when arguments get tested in front of a judge. So, if you are watching this case, here is how to watch it like a court watcher, not like a rumor account. Watch what the filings ask for. Watch what the other side files in response. Watch what the judge schedules. And most of all, watch what the judge signs. Because the signed order is what changes reality. Here is what we do not know right now. We do not know what specific discovery, if any, the federal judge will order about Bondi's prior work and any financial arrangements. We do not know how the court will frame the legal standard on recusal and conflict in this motion. We do not know if the judge will rule quickly or hold the issue for further briefing. We also do not know how the state evidence ruling will come out on the 18th of May, 2026. We do not know what evidence will be admitted. We do not know whether the ruling will accelerate a trial schedule or delay it. And we do not know if the federal and state lanes will collide in ways that change strategy, because that depends on rulings, not on predictions. But we do know this. This is a rare case where the public can see the legal strategy in real time. The defense is not only fighting facts, the defense is fighting process. And the government is not only pushing a narrative, the government is defending its authority to pursue the highest punishment available. So, here is the takeaway you can hold on to as we head toward January 9. The conflict claim is not a headline. It is a legal lever. If the defense can show the judge that the decision to seek the death penalty was compromised by a disqualifying conflict, the court could intervene. If the defense cannot, the motion becomes part of the record, and the case moves forward. Either way, the hearing forces the arguments into the open, and that matters, because public attention can distort a case. But filings can also protect a case by forcing claims into sworn, reviewable form. If you want the cleanest "what happens next" checklist, here it is. First, watch for any additional briefs filed before the 9th of January 2026, especially anything labeled as a response, reply, or supplemental memorandum. Second, watch for the January 9 hearing outcome, an order, a scheduling directive, or a briefing schedule. Third, watch the state deadlines leading into the 18th of May 2026, when the evidence admissibility ruling is expected. And, if you want TCAS to cover this the right way, subscribe for the filing breakdowns only. No rumor loops, no invented motives, just the documents, the timeline, and what the court actually does next. I'm Tim B. This has been a Court Filings Explainer on the Luigi Mangione case. The next dates are the 9th of January 2026 in federal court, and the 18th of May 2026 in the New York State case. When those rulings land, we will read them, summarize them, and show you what changed.